Sure.
Okay, so everything after this will be live.
Good morning, everyone. Hybrid meetings.
morning.
My favorite.
Good morning.
All right.
Morning.
So I'll start with the usual preamble. Hello, I'm Deb Stidham, and I serve as chair of the Addiction Counselor Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted in hybrid form with some attendees in person and some attending remotely. Jackie Lightcap,
Here.
Christina Boyd,
Here.
Lisa Carter,
Here.
Jason Hess,
Here.
Chad Jacobs,
Here.
Mike James,
Here.
Charity Kosen.
Here.
Did I say that right? Or is it-
It's Coxon. That's okay.
Dulcinea, are you on?
I don't see her on the call.
Yeah, and Shane Hudson, don't see him.
No.
Okay, all right. And I note that the following BSRB staff members are also present: David Fye, Leslie Allen.
Yes, and licensing specialist Sammy Barksdale is also present as well.
Yeah, thank you. All right, so David Fye will read a message concerning this meeting.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or COMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to a meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individuals requested to provide public comment. Because we are conducting this meeting publicly in hybrid form with some attendees in person and other attendees remote by conference call, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting in person or through the use of the conference call and on the board's YouTube channel. While the meeting is conducted in hybrid form, the requirements of COMA are not suspended, so we will be conducting this meeting pursuant to the COMA. On May 22nd, 2023, we sent notice of the advisory committee meetings to all individuals who had requested notice of advisory committee meetings. The notice also was posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other media material have been posted on the board's website and are available for review. You may also request a copy of the agenda specifically by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And we do have the conference call line active as well as the YouTube channel and also the Zoom.
Fantastic. All right, so the meeting's now called to order and we'll begin our discussion of the first item of the agenda, which is agenda approval. So has everyone had a chance to review the agenda?
I move to approve the agenda.
All right, thank you,
I'll
Jason.
second.
Thank you, Chad. All in favor, say aye.
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 Any opposed? All right, next item is to review the minutes from our last meeting on March 3rd. Motion approved.
I'll make a motion to approve minutes.
Thank you, Chad. Is there a second?
I'll second. Charity.
All in favor, say aye.
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 Any opposed? Thank you. Moving on to executive director's report.
Okay, thank you, Deb. So it has been an active few months since the last time the advisory committee has met. I wanted to go ahead and provide some updates. I'll start with some operations updates and talk about some legislative updates and then some from the past board meetings as well. In terms of operating updates, we do have a number of items we're working on behind the scenes here. There was the passage recently of substitute for Senate Bill 131 that we'll be talking about in a little bit more detail later on. But that is the bill that included a lot of provisions related to the Behavioral Sciences Regulatory Board. Behind the scenes, we've been working on implementation steps for some of those, as you might imagine, when there are changes to law. It involves looking at existing forms and thinking about creating new forms, working with the individuals who host our licensing system to make sure the technical details can be taken care of, changes to the website, and other ways of getting the notice out there about those changes. So we're working on all those details right now, and we'll be having more information come out, but I'll walk through a few of the items that were included in that bill here a little later. Also under operating, we did receive authority to hire 2 new licensing specialists as part of the package of that bill. And so that is something we're also taking care of behind the scenes, putting together position descriptions, receiving authorization to hire from the governor's office, and then going ahead and interviewing candidates and bringing in a couple new licensing specialists to help with licensing responsibilities. Additionally, we are making some technology improvements as well. We're in the process of transitioning about half of our staff over to new laptops through a desktop as a service through the state system. We've been going through a rollout process with that the last couple of years to make sure that we all have good technology here in the office. And also, we did receive some funding through the Spark Committee that was related to the COVID-19 pandemic for modernization of technology for state agencies. And so I put in 2 requests on behalf of the agency for grant funding, one to replace our existing projector here in the boardroom to allow us to do better hybrid meetings, and then also for the purchase of an OWL camera to allow us to do hybrid meetings as well, moving forward with new technology after some of the effects of the pandemic. And we were approved for both of those amounts, so we saved about a little over $2,000 for the agency. So that means we will be using that funding for those purchases, but appreciate the funding that we received for those things. Additionally, the legislative updates I wanted to provide, there has been some discussion this past legislative session concerning the agency's budget. We do not receive money from the state for operations. We do submit a budget every September, which estimates how much we anticipate spending, and the legislature sets a limit in how much we can spend on a yearly basis from the agency's fee fund. And that goes into an appropriations bill. When we went through the budget process this year, the House committee that heard the agency's budget added language that's called a proviso, which would restrict the agency from basically requiring education or training on diversity, equity, and inclusion, or critical race theory. And there were some other similar worded phrases that were put in that proviso when it went through the House. When it went to the House Appropriations Committee, they discussed that that should remain on the agency's budget, and they ultimately voted that it should remain on the agency's budget. That went to the House Appropriations Bill, and it was included in the bill that they passed. Now, the Senate does the appropriations process separately from the House. There was not a similar proviso the Senate added, but when the 2 chambers come together to resolve items of difference, that was discussed, and ultimately that proviso did stay on the agency's budget when it was sent to the governor's office for consideration. The BSRB does not currently require training in those areas or education. This involves an item that was originally in the BSRB bill that we had requested from the legislature this year. The board had made a recommendation for a new continuing education requirement in cultural diversity training. And I believe that's what they started asking questions about. And I think that was the origin of this proviso language. But ultimately, the governor considered the proviso as part of the appropriations bill. And the governor does have authority to do line item vetoes of certain items in the bill. And one of the line item vetoes that she did was on that proviso language. And so when the legislature came back to wrap up all of their last items during a period called omnibus, they considered overriding certain vetoes. They did bring this item to the House floor for a vote, and by 1 vote, the veto override failed. So, to make a long story short, ultimately that proviso language is not on the agency's budget for the next 2 fiscal years, which is what the original proposal was. So that language has been removed. So I just wanted to clarify if you had been tracking into that information, or if you had heard anything and wanted to resolve any kind of any questions or any kind of clarity on that issue. So both chambers did set a budget amount for the BSRB from our existing fee funds, and those were the amounts the governor had approved. And so there are basically some small increases in the next 2 years, primarily due to inflationary costs for a lot of the services that we receive, through agencies and entities that we contract for services. So I want to provide an update on the agency's budget, but based on where we are with the fee fund, I don't anticipate the agency will need to request fee increases on our existing fees, at least in the short term. The fees were decreased a few years back by the board in an attempt to draw down the agency's fee fund over time. And that is still taking effect. In terms of our revenue and expenditures, the revenue that we receive, it is less than the expenditures currently, but that is by design based on the board's action. And so we will see that, I anticipate, at the end of this month, when the fiscal year wraps up, that the fee fund will be going down, even with the new costs that we'll be absorbing as part of the new bill. Any questions on the budget? If not, I'll go on to the next legislative update. Okay, another legislative update, I mentioned the BSRB bill. That was originally included as a House Bill 2340. When the legislative session ended, it had been combined with two other bills within substitute for Senate Bill 131. And included in that bill, there were several different items. I just wanted to update the advisory committee on the items that were in the final version of that bill. One of the items related to the BSRB was a proposal the board had put forward for reciprocity for different applicants and many of the professions for the BSRB. For a number of those individuals who apply for reciprocity, the existing language would require that you come from a jurisdiction with substantially equivalent license requirements, or that you have practiced in another jurisdiction for 48 of the last 54 months. That is being reduced to 12 months. And so I should mention too, the items in that bill, substitute for Senate Bill 131, the implementation for those items, that would not occur until after July 1st. That's generally when publication of the statute book takes effect. So any of these changes I talk about today, they're not in effect right now, even though the bill has passed, but after July 1st, we'll be able to start utilizing some of these new items. The second item has to do with creating a new type of temporary license for the social work profession. We had been, the board had been working on a solution to individuals who graduate from programs that are currently in the accreditation process, but for social work that can take about 3 to 3.5 years. And the question was, how should the board view these applicants from programs that are in something called candidacy for accreditation, where they're making steps towards accreditation, but they are not yet from an accredited program. And so the new language allows us to issue a temporary license to those individuals during that time period where their program remains in candidacy. And then if the program reaches full accreditation, then we can issue them a permanent license as long as they have met the other requirements, such as passing a license examination. Additionally, the student temporary license for addiction counseling, that is an item that is in the bill. And as after July 1st, we'll be able to start accepting applications for individuals for that new student temporary license. And I asked Leslie Allen if she could just provide sort of a summary of that new student temporary license. I know that you all spoke about that and forwarded recommendations on 2 different student type licenses, one for the bachelor's level, one for the master's level. The board ultimately made a recommendation to go forward in the bill request for the bachelor's level right now. And so I thought maybe this would be a good opportunity for Leslie to kind of remind the advisory committee about some of the items that are part of that student temporary license for addiction counseling.
So the student temporary license the initial one will be for 24 months. And it's renewable for another 24 months if they're not done with their education. They have to have at least 60 credit hours in addiction counseling or related fields in order to start the process of getting the temporary student license. They have to provide an attestation indicating their desire to pursue licensure as an LAC and the plan to complete the education requirements within 48 months. They have to have a signed education plan, taking steps to obtain the necessary coursework. We have to have an attestation from a prospective employer who intends to offer employment once they get their student temporary. And they have to have a plan signed by the supervisor from the prospective employer. That supervision for a student temporary licensee is at least 4 hours per month. They have to have at least 2 sessions and at least 2 hours must be individual and the other 2 can be group. They have to be 20 years old and they have to pay the fee and merit the public trust.
So thought it'd be helpful to use.
No fireworks?
Right?
Yeah, do you all have any questions about the new student temporary addiction counselor license?
I do have one question, David, or Leslie, the 60 credit hours getting completed. How did you phrase that, Leslie? Did it have to be specific to social science and addiction coursework or just 60 hours of academic credit?
It has to be addiction counseling or a related field. And related field is over at the, that regulation is over at the AG's office right now, but it includes the behavioral sciences and human and family.
It's fairly broad.
Yeah,
I was just pondering that piece for those that have completed an associate's degree, which is about 60 hours total, but that includes English, math, science, all that kind of stuff to get to the 60. So,
We figured it would include things like that.
okay.
That's why it's not overly prescriptive.
Right, because if it's specific to addiction or just social science piece, they're going to be pretty much done with their degree by the time they get to 60 hours. So they shouldn't need the 2 years to get through it.
But I think there was a lot of positive comments about the student counselor license. We've received a lot of questions. The staff members have informed me that they're receiving calls from people that are anxious to start pursuing that. So I think it's a really positive step. Thank you for all of your work on that. Well, and I wanted to provide a couple more updates on items in that bill. So one of the items we had talked about for temporary licenses, the current language allows them to 1 year for most of the professions. There's a couple of them that have temporary licenses for 2 years. But the board recommends this all the temporary licenses.
David, your audio is kind of going in and out right now. I'm not sure why. It was perfect and then it just started going in and out.
Okay.
Yeah, I'm having a hard time hearing too.
Well, if it continues, go ahead and let me know.
That
So-
sounds better.
Okay, maybe I need to talk directly to the owl in front of me. We have the owl camera, so we can all see the little owl, but so on the temporary licenses, the board recommended making all the traditional temporary licenses 2 years to allow individuals who are struggling to pass the licensing examination additional time to be able to work under that temporary license while they are studying to take the exam and taking the exam, and then also provide more security to workforce issues. Temporary employers can know that if somebody has a temporary license that would last for 2 years, or hopefully it would last shorter than that if the person passes the examination and gets their permanent license. But thought it would be a helpful option to help out different people. So that will be going into effect after July 1st, 2023. We have had some questions from individuals about if the existing temporary licenses can be extended for that additional second year, but the bill doesn't authorize us to do that. So basically, after July 1st, we'll be able to start issuing the 2-year temporary licenses instead of the 1-year license, but we won't be able to modify any of the existing ones that we've already issued. So we'll be putting out some information on that just to clarify any kind of questions. Another item is essentially creating a pathway for individuals to stay licensed if they have had an extreme situation come up. One of the requirements to renew your license is to obtain the number of continuing education hours for your level of license, and different professions have different numbers. However, there are cases where someone has an extenuating circumstance that's extreme that prevented them from completing all their hours. And currently right now, when you renew your license, you have to attest that you have submitted all those hours to be able to renew your license. And so one of our professions had an ability for individuals to request more time to complete those hours. That was the licensed psychology profession. And the board thought it would be helpful to allow a similar flexibility for the other professions if someone can demonstrate that they had an extreme situation. So the modified version of that the board put forward in the bill was that if someone is coming upon the end of their license period and they have not completed all their hours, they can submit a request to the BSRB which have to demonstrate, like I said, extenuating circumstances and extreme situation that prevented them from completing the hours. But if they can demonstrate that, the board can approve them to receive up to 3 months of additional time to complete the continuing education hours. Now, this does not extend their license. They will still need to renew their license by the normal time. But normally you wouldn't be able to do that until your hours are completed. So this would allow you to stay licensed, get additional time to complete your hours. And then once you had submitted that, then you would be able to continue on without any kind of interruption. So part of this was looking at workforce in a different way. A lot of the workforce conversation has been on people coming into the workforce from the first part of the process. But I think being able to retain current licensees is part of that conversation as well. So that is something in the bill too. We'll be able to start helping individuals with that part too. Additionally, there are also individuals that over the years have allowed their licenses to expire, either because they have had a health situation or someone close to them, or they've experienced burnout, or a number of different factors could lead to that. But also looking at workforce from this direction too, there may be individuals who would like to come back to the profession and practice again. But to do that, one of the requirements is you have to show that you completed all of the continuing education hours for the last time period before you can have your license reinstated. Well, the board wanted to allow some flexibility to allow people to reinstate their licenses more quickly and easily. And so for individuals who have been out of the profession for at least a year, they would be able to apply for a new 6-month reinstatement temporary license, which would allow them to start working immediately with that temporary license, and they would have 6 months to finish up any of those hours that they were short to have their license permanently reinstated. Additionally, for people who want to reinstate their license currently, you have to pay the renewal fee plus essentially a reinstatement penalty, which is equal to the license renewal fee. So you basically are paying double the license fee to reinstate your license, but that could be seen as a barrier for people to come back. And so basically, if you've been out of the profession, if your license has been expired for over a year, this would allow you to come back at half the existing cost, what you would be doing right now. So if your license had been expired for a year, you come back just for the cost of renewing your license. So decreasing the cost and also providing flexibility for the CE requirement. But just another way the board was looking at improving workforce issues and providing more flexibility. Really excited about those items too. And we'll be reaching out to individuals whose licenses have expired over the last several years to make them aware of these things and see if they would like to come back to the professions. Additionally, the board had put forward a new requirement that would decrease the existing number of continuing education hours in diagnosis and treatment from 6 hours to 3 hours, and add a new requirement of 3 hours in cultural diversity. The legislature looked at that item. That when the House committee considered it, they removed the language that would have added the new cultural diversity continuing education requirements. So that item was removed from the bill. But the House committee decided that they would like to decrease the number of hours in diagnosis and treatment from 6 hours down to 3 hours each license period for individuals who would have to do that. And so beginning on, I believe it's July 1st of 2025, the continuing education requirement would change for individuals after that point. So for those of individuals that would need to get 6 hours in those categories, that would decrease down to 3 hours beginning after July 1st of 2025. And additionally, there were a number of cleanup items and items to add more clarity to the statutes. There was some items for the profession or licensed psychology profession in terms of changing their license requirements from good moral character to meriting the public trust, which makes it more consistent with the requirements in other states and the other professions for the BSRB. It also, there were some changes for the behavior analyst profession in terms of some of their disciplinary remedies. They did not match the ability for us to provide low-level sanctions against individuals if they had committed unprofessional conduct. For example, the statutes, when they were added for the behavior analyst profession, they included only the ability to suspend a license or revoke a license, but the other professions have things like have a small fine or do a public censure. And so now their disciplinary remedies match the other professions to allow us more flexibility to have those matched if there is a violation. And I mentioned some other statutory cleanup items as well. In terms of some new items the committees added, they did create some changes to the operations for the agency. One is to have a new requirement put in law that the BSRB would be sending notifications to any applicants for license, permit, or registration, letting them know if they have a complete application, and if they don't have a complete application, what else is missing for their application to be considered complete. And then there's a new requirement that once we have a complete application, the BSRB is to issue a decision within 30 days of having a complete application. Also, there is new language that would call for the board to create an expedited license process. And that would be defined and established in rules and regulations. And so that is an item that the board will be working on in the future in terms of setting that up and outlining that policy. The bill itself did not actually speak to how that policy would work, but just the board would establish that in rules and regulations. So that's an item the board will be looking at. Additionally, they made some changes to some of the statutory requirements for individuals seeking clinical social work licensure, removing some of the required coursework, and also changing some of the terminology in terms of the number of direct client contact hours that individuals would need to be performing and diagnosing and treating individuals as part of the hours they need to accrue to become a clinically licensed social worker. And also there was language that creates a new type of, it's called a community-based license in the bill. And this bill, the new community-based licenses would last for 24 months. So they would line up with the new time frame of the temporary licenses. But these community-based licenses would be for individuals who could show that they were working under the employment of a community mental health center, psychiatric residential treatment facility, PRTFs. They would also be able to work under FQHCs, and then there are other addiction facilities that were outlined in a specific statute. And so if the individuals can show that they're under the scope of employment in one of those different categories, it would be under the supervision of a clinical practitioner, then they would be able to submit for a community-based license as opposed to the traditional temporary licenses. And so that language was in the final version of the bill. And so that did get passed as well. So that is something that's new that we'll be rolling out as well for, it doesn't include all the professions, but I believe 5 of the professions are covered for the non-clinical level of licensure. Aside from the licensed psychology, it doesn't include that level of licensure, which is the only level for the licensed psychologist. So, but at that point, I'll go ahead and pause and see if there's any questions on any of those items I talked about in the BSRB bill. No? Okay, then I'll move on to the next legislative update. There was another significant bill that passed. This is for another profession, but there was a multi-state compact. It was House Bill 2288 for the clinical level of professional counseling. And that bill did pass. There was actually a ceremonial bill signing the governor put on. And so that was done. And we are now a member of that compact. The bill itself takes effect July 1st, but we were able to start taking some initial steps in preparation for that. There is a compact commissioner for the state of Kansas who will be attending meetings, and Laura Shaughnessy, the board member for professional counseling, has been appointed by the board to be the commissioner of that commission. And then additionally, there was passage of Senate Bill 66. And 66 is a bill that basically would create a license verification portal for the professional licenses in the state of Kansas. And so what it means for the BSRB is that we'll be working with the Office of Information Technology Services and probably the Department of Administration in terms of making sure that our licensees' information in terms of the verification portal we use is linked to this new portal that will be formed. I don't believe it will create a lot of changes, and we will still have a verification portal on our website, but it will basically, it's attempted to be a one-stop shop for the way it was described is for military members. If they're moving quickly, someone would be able to go to one place to check to see if they hold any professional licenses in Kansas. And so this will be developed over the next few years, most likely, but that bill did pass. And so we'll probably have to be assisting with any changes for that. In terms of some updates from board meetings, the board did meet on March 13th. One of the items was that the chair of the board appointed Zenova Williams to serve as a new member of the advisory committee. Her first meeting will be in August because that's after the start of the state fiscal year. which begins on July 1st. So I have welcomed her to the advisory committee and provided her some initial information. Also, the board approved advisory committee recommendation to add the National Addiction Studies Accreditation Commission, or NASAC, as a national accrediting body for the addiction counseling profession and regulation. And the board approved the other requested changes to the education regulations, which you had discussed, and made recommendations to the board for those proposed changes. We were able to add those changes to the regulations to ones that were already working through the process. And so those have been through the Department of Administration, and they are currently being reviewed by the Attorney General's office. Just to give you a little information on the regulatory change process, it has to be drafted and then submitted to the Department of Administration. They have the ability to have us make modifications to language and changes. And then after it goes through that process, it goes to the Attorney General's office. They have the ability to review and send back comments to us as well. And then after that, it would be held open for a period of 60 days to allow public comment to the agency. During that time, we would schedule a public hearing at the end of that time period. And we would also go in front of the Legislative Joint Committee on Administrative Rules and Regulations to inform them of the proposed changes. So those are the next step in the process. Once it goes through those stages, so long as the board is still in favor of making those changes, there would be a final review and vote by the board, and then they would be published in the Kansas Register. So with all those steps, the hope is that those could be made permanent sometime later this fall. Additionally, at that meeting on March 13th, the board entered into an agreement with the Center on Credential and Education to do some educational equivalency reviews when an expert is needed. We hope to use that company to increase the number of reviews that we're currently doing. We currently utilize some experts here in the state of Kansas to do some of those reviews, and we really appreciate those individuals. And we'll be continuing to work with them as needed. But based on the number of individuals who have been applying from other states that need the expert review, we wanted to be able to have other resources to go through those more quickly for all of the applicants. Additionally, at the board meeting on May 8th, 2023, the board went ahead and reappointed several advisory committee members. So I want to say congratulations to the members of this advisory committee that were reappointed to serve another 2-year term. That includes Lisa Carter, Shane Hudson, Chad Jacobs, Mike James, and Charity Cosson. We really appreciate all of your service on the advisory committee, and look forward to working with you all over the next couple of years as we continue to work on different topics. The board received proposals for unprofessional conduct regulation changes from the advisory committees. And what we did is we combined all the proposed changes from each of the advisory committees, put it together in one packet, and then inform the board that those would be going back out to the advisory committees. So you could look to see what other advisory committees had considered for changes, to see if you wanted to make further changes to your recommendation. And the goal is still for the board to make recommendations on final changes to the regulation, probably towards the end of this calendar year. And then also, I mentioned Laura Thomasy was appointed as commissioner for that professional counseling compact commission that happened at that meeting. And then the board confirmed that it intends to do its annual offsite planning meeting in person again later this year, probably in the end of September or in October. And then just one other item I wanted to update the advisory committee on. There are 3 board members that are expected to end their time on the board at the end of June. That includes the chair of the advisory committee, Deb Stidham. She is ending her 2nd term on the board. And then Rick Steele, board member for licensed psychology, is ending his term on the board. And Donna Norton, public member, is also ending her term on the board too. So we anticipate the governor's office appointing 3 new board members. And so we will make everyone aware of those new members once we have appointments from the governor's office. So I will go ahead and end my report and answer any questions.
Any questions for David?
That's it. That's all you got?
There's a lot more I could talk about.
Doesn't sound like you've been doing anything for the last.
Well, there is one other operating.
Yeah.
Well, and I do have to give the staff a lot of credit too, because I definitely could not do, the number of things that we do around here without the good assistance of everyone here. There's lots of operating things that go on behind the scenes, helping out with different entities, but we are currently looking at replacing some of the furniture in the office too. So these boardroom chairs we've had for many years, but we are hoping to go ahead, and we're meeting with someone actually later today to look at some. So It's a needed change, but just trying to move forward on lots of fronts.
I don't, if you said this, I apologize, but then we also get the added bonus of putting on an RFP for our legal service.
Oh, that's correct. Yes, that's been something we're working on this spring.
Yeah.
That recently has closed, and so the members that are part of that team will be reviewing that information and then looking at that as well. So yes, there's been a number of different items going on behind the scene.
All right. Thank you, David. So the first, next item, I should say, is old business discussion on unprofessional conduct regulations from other professions that David mentioned. So I know we've had these in front of us a few times over the last probably year. And we, what you see before you for hours, are things that either recommended by staff to clean things up, or was something that we discussed and put into something we wanted. So I don't know if folks had an opportunity to really look at the other professions. I can't say I went through with a fine tooth comb. However, there were some things that jumped out at me. So I'll just start and then see if anybody has anything to add. So a topic that I saw in another, maybe all three professions, has to do with the use of social media, and I did not see that in ours. So if my notes are right, looks like professional counseling, marriage and family therapy, and social work all had something to do with social media. Yeah, so if you look at marriage and family therapy as an example, you might know whether they all use the same language or not, but
I think two are the same and one is slightly different.
okay. So at the back there under 54, it says practicing inappropriate boundaries with clients with regards to the use of social media, including but not limited to using a personal profile to connect or communicate with clients on any social media platform, or disclosing confidential information through public social media. It feels like in this day and age, we should have something in there on that. I like the term practicing inappropriate boundaries. I don't know that I
agree.
die on a hill about communicating. There might be an extenuating circumstance to communicate with somebody, to reach out, or are you okay, or that kind of thing. And if that's not be all end all for me, but
Well, I think. we
if
need
it's
something in
inappropriate,
there.
if it's,
We've just speaking from our agency's perspective, we've had unlicensed individuals that we've had to address some issues around social media, contact, appropriate relationship, those kinds of things. Those behaviors certainly aren't just bound to the unlicensed folks. It's an easy thing to cross the boundary line when you get into whatever social media content you're involving yourself in. But I agree with you too, Deb. I'm not willing to die on a hill about language.
it's our age.
So I know.
Not today, Jason, right?
Copy paste somebody else's and I'm good.
So professional counseling, if I'm looking at theirs, which is number 56, it talks about similar, they've added or accessing a client's social media pages without previous consent. I like that.
Yeah, I can tell you a little bit of some of the conversations about that too.
Okay.
So the original language that was being reviewed as a proposed change included the full information here on the professional counseling item. The conversation, if I recall correctly, for marriage and family therapy was that if you receive information that there may be an issue with the client's social media, is clicking on a page, should that be a violation, or is that something that would be reasonable for a practitioner to, if it's a public page, to be able to view something like that? Or if someone shows you something that you didn't go to, but someone is like, oh, did you see this? Should that be a violation? And so they decided for marriage and family therapy to remove that piece of it. And one of the things on their recommendation too, and this may be in both Yeah, I think it's in both. So it wasn't necessarily all communications with clients through social media. It was about using a personal profile to connect or communicate with clients.
Okay,
And so there are some individuals who may have, professional page or something, but there's a difference between having a personal profile versus the professional page. So I think some of those were part of the conversation.
okay, thoughts?
So I think this gets tricky because I think there's the difference between what's legal and what's ethical. Even if it's a public page, I don't drive around people's homes. That's public, right? And look in their windows. I think that's where some of these things get outlined in just the ethics of a discipline and how far we want to take that, I guess. But like Googling a client, what is the intent? What is, which again leads to social media pages, those kinds of things. And then where do you document that? How do you talk to the client about that? Does it need to be informed consent that you might do that? All of those things come into play. There's actually a lot of commentary and research out there, literature on this, because it's such a big behemoth of a topic. With other disciplines, social work, for example, they have the tech standards that came out in 2017 that just very straightforward say it's not okay to Google a client. It's not okay to friend a client. It just implies a different relationship. And then again, you get into confidentiality issues because like with the social media, everything that's on Facebook or Messenger is that's Meta's property. Like you don't own that. And so anything you put on there becomes not confidential. And so even in communications, I mean, there was allowance of that during COVID times because it was crisis and we needed to get a hold of folks. But I think it's just that knowledge that nothing you put on there is secure. And so is that opening a door? I don't know. But I mean, there's lots of implications of this, I guess, in considering those things. I hear what you're saying too, Jason, about, with peer support that I've actually reached out. We're doing some, I'm trying to gather information on that. Like what are the boundaries? Because it's about boundaries and self-disclosure. That's basically the ethical principles that come into play there. So how do we, you know, manage that in today's age? I mean, clients can go on and Google you, right? Like they can find all this information about you. But that just because we can doesn't necessarily mean we should.
So it,
Well,
it are-
you always run down the path of pre-existing relationships when
Yep.
you have conversation, especially in small communities where, you're already Facebook friends with somebody and they come in and they become a client of your agency. They're not your particular client, but do you then suddenly, because we've written something in a way that's so prescriptive that you violated ethical principles because you're a friend of, and it's just, you have to be somewhat vague in the language, so it becomes an actual investigative piece as opposed to a prescriptive piece.
Oh, go ahead. Sorry.
I know at our facility, a lot of our connections come through Facebook Messenger because a lot of the clients don't have the same phone numbers. And so to do follow-up, but what we do is have them sign a release and a consent at the very beginning of their treatment if they do not want any social media. But a lot of our girls come back through because they messaged me and they were like, I'm struggling. Can you help me get some help? But we make sure that we have releases in place at the very beginning. I think in, this day and age, it's just been a helpful reconnection tool and a way to do 6-month year follow-ups to see how they're doing.
And I agree. It is something that can be easily accessible. I just think that there's implications of the privacy issue. Like, how is Meta taking that information? They scan all of that. Are they then getting, ads for treatment, or, like if multiple family members are using the same device, and then that retargeting is happening. Google has admitted it, Facebook has admitted it, like that is a thing. And so then it becomes privacy safety issues, because if they're retargeting and sending those things out, and again, multiple family members are using that device, then have they just, there's just, again, I think a lot of implications of that, and that Meta has that information then. I mean, when you sign up for those services, it's in the small print that's theirs. They can look at it, they can do whatever they want with it. I just think sometimes people, it's informed consent, but also recognizing the dangers of that and the implications of that. It seems benign, but could have some ramifications down the line, especially when we're talking about confidentiality. To me, that's a big issue around confidentiality, and so we just have to be very cautious, I think, just how much data is being mined right now, through those social media channels.
I agree with you completely, Christina. The challenge I think that I'm encountering with dealing with the young students in academia is that's where they communicate. Period. You could give phone call, they won't answer phone calls. You can do emails, they don't answer emails. But if you're on social media, yep, they'll respond to that stuff. So it's the clientele, or where are they? And I think the young folks absolutely don't even consider that data mining thing an issue. So,
Yeah.
so I'm not sure what that means for how we word these things, but it definitely needs to be part of our thought process of there has to be a mechanism for how do we utilize that, and the releases are the one we have currently, but we should be very cautious with, I agree, very cautious with it.
That's what I'm thinking too. Like, could it be handled in a disclosure that they sign? And another thing, it's easy to flip flop between personal profiles and professional profiles, but I'm just trying to think of an instance where you would engage personally. I mean, I just wouldn't do it. If I was going to be doing it at all, it'd be through a business profile of some type.
I agree. And I mean, there's a lot of platforms out there that are encrypted and again, that meet the standards for, for privacy and confidentiality. And so even if, like you're saying, Michael, I mean, I think again, meeting people where they're at, very, very important. And sometimes, and we also have to be, advocates for privacy and confidentiality. And so, are there other ways to ensure that there's an app? There's ways to encrypt those things so that it doesn't put it out there. Even, Verizon, those kinds of companies are starting to look at, I just saw the other day, somebody had an ad about that encryption. Like if you send a message over text, for example, that's not secure unless you have encryption and go through VPN process to ensure that, because
Okay.
those short message can be pilfered. Basically, there's people out there doing that all the time.
Agree, and I always send the individuals that come to me from Academic Sense and the other places to go, hey, go over to this, communicate with me over there, and they'll do it for 2 or 3 times, and then they're back to the insecure one afterward, because that's the one they use all the time. It's hard. It's difficult.
Yeah, I think even at the beginning of this conversation, I was thinking informed consent, I think we have a responsibility to have that as part of our informed consent process. I think a lot of agencies have already gone to that with the use of texting to remind about appointments, or, what is your preferred, and be aware that, but that's not really what this says. Do we want to leave it alone? Do we want to, what's the time frames for the?
Well, I definitely think you would have another meeting for sure to
Okay.
continue the discussion. The hope is that recommendations can be forwarded back to the boards. The board can make recommendations to the changes, the regulations by the end of this calendar year.
Okay.
So I think there would at least be another meeting, if not 2 more meetings.
Yeah. For me, if we're going to have something in here, I would like to see some phrasing that includes informed consent. Because then you have an opportunity to actually educate our clients as well about all the things you're talking about, Christina.
Yeah, I had the same thought, Deb, like I almost envisioned like do you know, one-page flyer about, you know, the social media and your confidentiality. It's an educational opportunity.
Sounds like a workshop, Christina. Yeah.
Oh,
Christina.
I do these trainings all the time, actually, through the ATTC, or well, not the mid. Anyway, doesn't matter. Yeah, I mean, I think, yes, I think that this is something that I think people want guidance though, and need guidance. There, you know, there is some helpfulness in having something that's, like Jason saying, a little ambiguous, because there's always going to be examples of, you know, circumstances and things. I mean, I do think in emergency situations, that's where, you know, being able to look on a social media page or find out, you know, family members, someone's made a you know, intent to harm, you know, those kinds of things, those are extenuating circumstances in which, you know, accessing those kinds of profiles and finding, you know, people and all the things that technology can do. I think those are going to be the very minority. That in general, you know, I know that I've spoken with agencies that their practice is to Google everybody or to look at the social media pages, and it's the intent is not for safety. It's, you know, there's other things there. Probation, parole, like that's a common practice that they do, but that doesn't mean that for providers that the same kind of rules apply or that we have the same intent in doing that. Again, it then comes up about, how do you tell people that? How did you get that information? Why did you get that information? Where does it go? Does it go in the chart? You know, all of those implications in that process. So, yeah, I don't know. I think it may be helpful. I don't know if other states, do you know, David, have other states, have they kind of drafted these things? You're talking about other disciplines within Kansas, but do we know how others have addressed this?
It's a good question. I really don't. I'd be happy to reach out. There's a small number of non-cabinet agencies that I speak with their directors fairly often, so I could check to see if they have a social media regulation or something like that.
Okay. And that might be helpful because, again, I think during COVID, there were a lot of allowances that specifically said, like, we're not going to be sued if you use these social media channels, but that doesn't mean that individually people couldn't sue. You know, like that was one of the things that we kept bringing up, is that protection was only in, you know, from that confidentiality in a pandemic time when there were, you know, emergency situations that could go away at any time. And also it doesn't protect against individuals suing if they feel that their privacy has been violated. So I just think, yeah, some guidance there would be helpful.
Good discussion. Another point of slight variance that I found had to do with the discrimination phrasing. So that's an L for us. If you look at professional counseling, well, theirs is a bit longer. They added things like socioeconomic status, immigration status, marital / partnership status, language preference, culture. And they also added, or any basis prescribed by law, which I like. As laws change. Hopefully not getting worse, but getting better.
Well, and just for some background on this, because you mentioned there are some differences between the professions. This is a challenging one because, we do strive for uniformity between the professions and we can achieve that. On this, a lot of the advisory committees basically said, we would like something that's consistent with our national association in terms of if they have the direction in terms of discriminatory policies or anti-discriminatory policies. And so this might be a little tricky between the professions because we do strive for uniformity when it's possible, but then some of them might also want to match what their national association says too. And some of them did ask questions about, can they use the same language from their national association for unprofessional conduct or conduct in general? And we basically said, our legal counsel has said, we don't want to delegate authority to a non-state entity in terms of adopting someone else's policy, but any of the language they use could be brought over and included here. So now for your profession, it's a little bit different, but I think you do some flexibility for whatever you want to include there.
Okay. Marriage and family therapy under 12. They have included status in any other marginalized group. They also have health status in addition to disability. I guess I'd just open it up to see if we think there's anything we want to add to our definition. I probably like professional counseling. If we just want to say, well, we like theirs, we'll just take it.
That's the only issue that I take with that one. Really comes down to having to pay attention to what funding can be used for and what can't. The only words that I have it with professional counseling was immigration status.
Mm,
When we say
mhm.
immigration status, that also includes illegal immigration, and my agency has plenty of funding that's coming in.
That you cannot,
Can't be used for illegal immigrants. I just have to be careful about that.
sure.
And it being viewed as discrimination, right? Something that we manage on a day-to-day or week-to-week basis to make sure that they get services, but there are some things they are just not eligible to receive. And I understand the intent behind the word,
Mhm.
and there are plenty of immigrants that are here legally that have every right to all of the benefits and services that we all are eligible for. But without displaying that,
Mhm.
you push some folks into some trouble because of the way money comes to the organization.
Makes sense.
Other than that, I'm good. That's the only reaction I had.
Other thoughts? You want to chew on it till next meeting? Okay, I'm taking that as a yes. Let's see if there's anything else in here I saw. There was professional counseling has something on distance counseling that I didn't see in ours.
It's at the end of it,
I think
Distance.
58.
58 on professional counseling, way at the end. If engaged in distance counseling, failing to fulfill these requirements, A, informing the client of risks and benefits of distance counseling, B, disclosing the possibility of technology failure and providing alternative methods of service. C, detailing emergency procedures to follow when the counselor is unavailable. And D, taking appropriate steps to encrypt or ensure the security of confidential client information or any activity which protects confidential client information from risk of privacy breach.
That's specifically designed to talk about telehealth,
Well,
but then, you know,
that's how I would,
that's my assumption. too.
Yeah.
But
that is an interesting question, though. We know what distance counseling. I guess that would
Yeah.
mean also phone.
I think it goes back to the informed consent, though, just any communication that's not in person, you know, the client understanding the risks that, like Christina was talking about, or just the risk that somebody could, you know, it's just not completely private, and making sure the client understands that.
Completely.
Does that also, I mean, it seems to also go into some of the just competencies about, you know, crisis, right? Knowing where the person is, knowing the crisis services there, if something happens while you're in the session and you're not present with them, right, in physical space, and something happens on their end, what's the backup plan? Knowing the emergency services if you're across the state. I mean, it sounds like, if I'm hearing that correctly, like kind of gets into some other competencies versus just possibly the informed consent of risk.
I do see social work has nearly identical language in theirs. I did not find marriage and family therapy.
Because I do think that kind of gets into beyond just the risk of the technology use, but really getting into making sure, you know, crisis emergency kind of situations that's covered, you know, being a primary component of that, which I think is good. I mean, I think that's helpful.
I think through the use of these updates, we have an opportunity to include topics that are more relevant than when they were first drafted. And hopefully there will be some attention drawn to this by educators, supervisors, you know, folks that provide training. Hey, it's been updated. Now we're talking about these topics. So anything moving in that direction, I think, is a plus, even if, like, I don't think we should get too freaked out about exactly every single word. We want people to pay attention to what they need to know. So it strikes exactly what you're saying, Christina, about competencies. Where should we be placing our attention? Because the world has shifted in some pretty significant ways that affect practice.
Yeah, and I mean, I think there's other competencies that are involved in providing, you know, if we're saying distance or telehealth. I don't know that we need to, you know, necessarily, like you said, maybe prioritize a little. Like these are the really, you got to have these. Like these are the things that need to be there. There's obviously other things that are part of competent care. I think, you know, looking at some of those very basic things like safety, security, crisis, those kinds of things would be helpful to include for sure.
But at that point, are you restating then what the competency is? I mean, maybe that's necessary because distance counseling or distance therapies is really not different from in-person outside of physical presence. The competency doesn't change. Presumably, if you're meeting with somebody in person, you're putting that piece in place about safety and what to do in a crisis. And if I'm not here because I'm sick, what's your plan B? There is zero difference between being able to get somebody on a video or not we're being in person or not? Or is this just an attempt to restate because we feel like we need to address a technology specifically? Or, I mean, I don't know, that's where I end up struggling, because I mean, if we're going to say that distance therapies or telehealth is equally as competent as in-person, then all of those same competencies come into play with your work, correct? Maybe I'm missing the point.
I think they do, Jason. And I think you being a provider for a number of years, it almost seems like secondhand, but I do think having competencies that very much specifically, like, for example, if I'm in Dodge City and I'm providing care for somebody in Hoxie, I need to know what the crisis services are in Hoxie. I may be very, very fluid and aware of what my crisis services are here in Dodge City, Kansas, but that doesn't mean that I'll know what they are halfway across the state. And that's where they need to know. That's what they need to know. What are the crisis services where the client is located? So I think some
I
of
completely
this,
agree with that. I completely agree with that. And but I think that also plays into the same, if I'm in Johnson County and I have somebody driving up from Allen County to be treated, I need to be seen in person. I think that's where I'm questioning, do we need to call out telehealth or distance therapies specifically, when if somebody's driving 2 hours to see me for an individual session, I need to have the same knowledge of where they live as if they were living within my own community.
right. I think, and the difference being, if they come to Johnson County, say for in that example, and I'm sitting in an office and something happens, again, I know my resources there versus the resources where that, if I'm having a session, in the session, something happens, I
Right.
have to know, right? And I think, like you said, that's just good care, Jason. So I think
Yeah.
that may come intuitively to you. I don't know that everybody thinks through that to that degree when we look at utilizing a different modality, of distance or telehealth. I don't know, maybe. I mean, but again, I would hate to make assumptions that people just know to do that. But having that, again, the basics there, like Deb, what you're describing there, and the language that you went through, I mean, I heard in there some very basic safety things that have to be established that I think would be good.
I think there's two groups that I think about a lot about things like this. Brand new, kind of off the shoot. Maybe I'm a prodigy and I'm now in my clinical and I'm gonna go do private practice, and maybe my supervisor isn't so, right? Or old timers like me, who just kind of go, it's like, maybe it shifts and I don't really think through some of that stuff. Because I'm an old timer. What do I know what I'm doing. I don't need Jason's supervision.
Well,
So
nobody needs that.
so I'd like to think that 80% of the folks have, some built-in mechanisms that assure some of that stuff. Especially if you work in a fairly large agency, but that isn't everyone. I just think we have an opportunity through these to draw attention to them, get people to look at them with fresh eyes, maybe seek out some training that in some areas that maybe they really haven't thought about.
Also, because many states have a requirement for telehealth training, if you're going to provide that and we don't.
And that's, I was just going to say too, because I mean, I worked with the state of Florida, actually. They developed competencies that anyone providing telehealth has to have, and they have to take an exam to be able to pass that, to ensure that these, and there was a lot of work, there was a lot of months spent on developing basic competencies. Like, what do people have to have in order to translate, what we do in an in-person setting to a telehealth kind of setting. And I don't know that we want to go that far, right? Like, that seems not what we're talking about here, but to have some basic competencies that are required, I think, I think that I would support that. I think that's a good idea. And I can send like that, what was, like what they developed there. I mean, I'm happy to send some of that. And I was thinking of the earlier discussion too. I can send some of the resources on that out to David, then you can distribute to folks, and then that may help in some of the discussions.
Anything else jump out from folks if you had a chance to review these regulations from the other disciplines? Okay. Good discussion. Under new business, we're going to talk about discussion on types of changes necessary to be reported for clinical training plans.
And after I sent out the materials, I did send an email yesterday with basically just a copy of the document posted on our website about filing clinical supervision training plans. So I do have a copy of that if anybody at the table wants one, but it is posted on our website under the forms for clinical training plans.
Oh, I printed it for everybody. And highlighted for some reason. I don't know what I was doing.
Because you knew who you're dealing with.
I think I highlighted a few for some reason. I was like, I don't need to highlight.
Thank you, Sammy. Appreciate that.
Thought it was
And-
wonderful.
We are in the process of updating these forms to make some more questions, yes, no.
Okay.
Because even when you have people write out, what's your schedule for supervision? They don't do it. So are you gonna do this? This is what's required.
Are you gonna do it?
I can provide more context if you want for this item being on here. So I have been on the board for a number of years. And as you know, someone in that position, we have before us occasion where people have not submitted changes to their plan. And there's a various sundry reasons. I would say the number one reason is people forget. And apparently the sign supervisors aren't very good at reminding them, because the supervisor will often say, I forgot also. Sometimes, you know, and so the way the regulation is written right now is very specific and fairly binding, honestly, for the board. If you don't file your change within 45 days, that grace period, then if, let's say, a year goes by and you're actually like, okay, I'm done, or I'm almost done, I'm ready to be licensed, and you submit that, and you're like, okay, who's this supervisor? Okay, what's this work site? And so the language basically says we're not to count any of those hours because they failed to file in the 45 days. Probably of all the things that we've had to consider in front of the board, that's probably, for me personally, has been the most painful. Nobody likes to see somebody lose 1,000 hours and all that money, probably. And
Or all of them.
okay, thank you for making it even worse. I had minimalized it in my own mind. So, anyway, so the idea was, okay, should we look at this? And the decision was made to let the advisory committees weigh in. Bring it back, see what we think. I thought as I was reviewing for today, it might be helpful for everyone to see what is required initially, if you don't already know that. So some of you of course do. So I will just open it up for discussion. Obviously, COVID didn't help anything during this time either. I think I would like to think there's extenuating circumstances like a pandemic, that people would just be so consumed with everyday life that they kind of just miss that point. Or maybe, and I think this is what I attribute to some people, is they started out in one, you know, just working for someone in private practice, and they just went to a different private practice. Or their supervisor got sick, retired, quit, whatever. And so they picked up a different supervisor, but everything else was kind of the same. That's not always true for everybody, but so what is the intent behind this rule? This document of filing of clinical supervision treatment plan, supervisor training plan is quite long, quite prescriptive, quite detailed. So it kind of reminded me again of how people forget.
Yeah.
Yeah.
We got up in their business so much about what was gonna happen. And I'm not saying it happens all the time, but it happens enough that I think it warrants a discussion.
And I'll just add one note before the other advisory committee members jump in. If anybody is looking at the specific language from the public, the language on this item is in KAR 102-7-6.
If you got,
Which has professional postgraduate supervised experience requirement for clinical addiction counselor. And the 45-day requirement that Deb had mentioned is little item J. It's the last item in that regulation. And on the copy that we posted, we highlighted that section. But some of that information is also found in that document about the clinical supervision training plan in terms of the 45-day requirement. So just wanted to make sure people could look at that while they're adding some feedback.
Yeah, so this falls outside of honestly, my experience. When people send changes, how do they send them? What's the requirement to send a change? Is there a document? Is it an email?
There are different ways. You can, there's a training plan amendment form for a change of supervisor or adding another supervisor, and there's one for work site employment setting.
Okay.
The rest of the changes, they could just be sent by letter or email.
And
And
then
then go ahead.
Are those reviewed as they come in, or is there a specific time where you review all of them that have come in within a certain time frame?
No, they're reviewed in the order they come into the office. So we do it constantly. One of the bigger things that's not people who change positions in their agency. So you may be an intake therapist or, a crisis person, and you change positions. That new position may or may not meet the requirements for clinical license. So we say you have to tell us if you change positions, because we have to review it and make sure that if it counts initially, and if it does, are there things in that position that don't count? Like just your supervision, you can't count supervision toward your clinical hours. It's not part of the practice of addiction counseling for clinical license. If you're doing more supervision than client contact, things like that. And but that's one that happens a lot. People in their agency change positions and they say, oh, I didn't know I had to do that.
And concerning what types of changes need to be reported, in item J, the specific language says all changes to the clinical supervision training plan shall be submitted by the supervisee to the board for its approval. But understanding what constitutes a change, I mean, if you're moving from office A to office B in the same building doing the same job, that is a change, but it's not a significant change. And so I think one of the parts of this conversation too is I think there is a desire perhaps to add something to this regulation that can spell out specific changes that would need to be reported if the rest of this language does stay the same in the ultimate recommendation. But it could be helpful to add some clarity in terms of the specific types of changes. And then if that was made as a change, we could put that information out there and then let supervisors, give them more notice about the specific changes that they need to be aware of, and also the applicants too. But that's a piece of this too, is understanding what would constitute a change needing to be reported. The phrase all can lead some people to forget or not think it's a significant enough change that needs to be reported, which unfortunately does have a big effect sometimes.
Yeah, I think that's a good point, because I can envision, and I can't verbalize that scenario where it specifically says changes to the plan. And if I don't think it's a change to the plan, I'm not going to tell you anything. So So it's a bit of a subjective review, retroactive subjective review that feels almost automatically punitive. Which I can see where your heartburn would come in, taking 1,000 hours away from somebody when they didn't think that there was any need to say anything because they didn't see it as a change to the plan. But again, it's not something that I've had experience with, but others you have need to chime in. Just talking.
I have reached out to some of the associations for social work. We just had a meeting yesterday for some of the administrators for the different boards. And they are having a conversation about supervision in general too. And I spoke with them at the mid-year meeting a couple months ago, just to kind of see how our requirements line up with other states to see if we have similar requirements. And unfortunately, the topic of supervision is dealt with in many different ways by many different states. Some don't require a training plan to be submitted at the beginning at all. People just start accruing hours. And then hopefully when they turn those in, they meet the requirements, or else they have potentially wasted a lot of time and a lot of money. Other people do a submit as you go, and they have systems where you have to turn in your hours constantly throughout the entire process. This 45-day item, I believe some of the intention on this was to give people reason to submit changes so that we could verify that they actually would be something that would be approved. So I think the intention was to the benefit of the applicant. The problem is that the penalty right now is very significant. And so, but if you're wondering how these might compare to what other states require, I don't think there is a real standard, at least that I have seen, between the professions on supervision. So I think we do have some flexibility here to reconsider or think about creative solutions.
David, you touched on a thought that I had about it. You know, we are kind of in this day and age where we rely on reminders. I certainly do. I mean, I know by now, I've had licenses for so long when they're due, but you know, some people rely on that email reminder. And although there's this personal and professional responsibility to know what you're obligated to, it sounds like it doesn't necessarily, what's in the plan is one issue, but then people remembering, being notified, or some kind of scheduler is another issue, which you touched on with people having to submit at certain time increments.
So was there a idea of how that could be worded to maybe allow a little?
In some states, it's a requirement, so it would be a requirement. It would create extra work for the supervisors and the staff. But the hope would be that it would be better for the supervisees in the end.
To that point, what, I know that the number of cases we've had to do it feels heavy, but in numbers, I don't see the numbers because all these other ones, right, we're only getting the outliers.
Right.
So what is the percentage?
I would have to ask Joan.
Yeah, I mean, I would think it's safe to say that it's rare.
Yeah, it's low.
It's a low percentage that this happens, but it feels very unfortunate. Again, we're trying to be a little bit more accommodating. We've established that the language is very restrictive for the board. When I was thinking about this, because I'm trying to put myself in their shoes, these people working on their hours. And in my mind, what they're focused on is getting the hours. I'm seeing clients. I have someone watching me. I'm meeting with somebody. I'm doing what I need to do. My outer circumstances shifted. But honestly, if you're in this tier thing, you're like, that is what you're focusing on. Right. And I think that's where I think some of the mix-up is because in their minds, that didn't change. And to me, that's what the board's most concerned about. We're really not most concerned about those external pieces. So again, this is just off the top of my head thoughts. When we look at language change, if we do, I was thinking we could be a little bit more like, what is the heart of the matter? And so we would call those substantive changes or substantial changes or significant changes, and then what those are. So I wrote down setting, types of clients, and supervisor. And maybe there's something else. And then you have those forms that we're talking about. And to me, those forms need to go with this packet.
The changes.
Yeah. So if any, like, because I'm
No,
simple.
so keep talking.
Well, I'm
I'm
like,
looking confused just because you haven't
oh, I'm
finished.
used to that, Jason.
I know. I'm always confused. That's why you bring.
I don't- I'm just, I'm a simpleton sometimes. It's like, what are the 3 things I need to remember about my
Yeah.
clinical supervision plan and have that really outlined?
Yeah.
I hereby attest that if there's a change to my setting, type of client or supervisor, I will notify, and here's the form to do it. And then we could also add something, because right now the wording is no supervised hours of practice shall be accrued. I was just gonna give the board flexibility, may be denied.
So do they get a temporary license card?
No, because they're already probably.
they're already licensed.
Yeah,
They're
they're
already
already
on
licensed.
so they're working on their clinical, they don't get a temporary clinical.
Oh,
For us, it'd be an LMAC and they're
Yeah.
working on it
Yeah.
from there.
well, if we're thinking creatively, I was just thinking of if there's some kind of that. The
Oh,
card
yeah.
is issued to put that information on the back of the wallet card.
So personally, I'm not a big fan of going down the, let's do everybody,
Mhm.
if this is a small number.
Mhm.
Well, I think that's the important thing to think about because that's a great point. It feels heavy, but do you change a rule for the 2 out of the 10? 3 out of the 10, at what point do you change it? Because it's finally significant.
I do like the thinking around the wording change of maybe approved or maybe.
Maybe denied, you have to
denied.
change it.
You'd have
you
to
know.
change that sentence at the end of that sentence,
Right.
but. It doesn't necessarily change the rule. It just means that the board has consideration
Mhm.
for it.
Yeah,
I also, where is it that you put this is the type of change we're looking to get information on, because.
Yeah.
Because again, you get a whole bunch of people. Reading the rule and saying, well, you're gonna, I mean, I know it doesn't happen, but I think, God, I could just imagine the emails coming in. Like you said, I changed desks,
Right?
here's my change.
Yeah.
And
I
happen to
changed the
review
goal.
crap like
I've
that.
added a goal.
Yes,
yeah.
right.
I don't get that, but yeah, some people think that the goals are important. Well, they're
Yeah.
obviously constantly changing as you're improving.
Right, and I think one of the factors in here too is from the licensing body's perspective. Our staff want to be able to clarify things if someone calls and asks a question.
Yeah.
And they want to be able to defend the line too when they think that that's what they're supposed to do. And so they want to be able to have clarity on these items too. So that way they can inform the public and know what they should be saying and what they shouldn't be saying. Definitely a good topic for us to be working with.
Yeah.
I also agree with Jason and Deb there just about if you're able to change the language and that gets to the purpose of this as those individual cases where it was just something that was small and they just, it happens. And then that gives the board that flexibility. I think that's a great idea. I also support that.
Especially since, your task is public safety.
Mhm.
And so if public safety wasn't compromised,
Right. Right. I think at the end of the day, you don't want, if we're gonna continue to require the plans to be submitted for approval, you don't want a complete departure from the plan,
right,
because then what was it for? Like I
Right.
could say, oh, here it is on paper, and a month later, I'm off doing what I wanted to do.
right.
Right.
We don't want
That's public
that,
safety.
but that's probably the outlier of the outlier that would do that. So, what are we really trying to manage? And I think that just to think about what is the heart of the matter? What are we really trying to influence? So if there's something other than, or different words or whatever, to setting types of clients and supervisor.
I think that piece of, allowing the board a little bit more flexibility would be probably the most important component. Because if they did make a change, they forgot to submit it, but the change would have been approved. And
Exactly.
you have to deny all those hours because they didn't remember to submit a form. Yeah, I could see a lot of heartburn with that, because that is a arduous process to go through. But those that don't do it and it wouldn't have met, then the board does still have the capability to say, well, they didn't qualify, so we can't give you those hours. Had you informed us, we'd have fixed it. You'd been able to fix it. So I think that piece might be the most important
Yep.
component versus even kind of trying to anticipate what's the most important change. Because I know Leslie said, well, sometimes the job description changes in such a way that it doesn't fit anymore. So then that's a little bit harder to say, simply in regulation, those kind of changes that need that individual review. I don't know, just thoughts.
And it will increase the board. What
Looking at
comes to the board, yeah, because
Okay.
many people, when you say, well, you didn't submit your change and blah, 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 they say, okay. And they haven't come to the board. So there is more than what the board has
Oh,
seen.
okay, it's good to know. In my mind, adding, instead of all, you could put substantial changes. You could increase the grace period, if that even matters. I don't know how many people are close to the 45 days. You can
Not
go
that
to
many.
60.
Yeah,
And then add the may be denied. And then send out, here's, the forms that go with it.
right.
And it's around these topics. So you kind of directed them what the substantial change is.
Well, and if you use language like substantial changes shall be submitted by the supervisor to the board for its approval, included but not limited to, and then you spell those out. If there is a significant change that we didn't factor in, the board still can consider that, but then having that flexibility language allows the board to weigh it to see the reasonableness.
Did you also say that you wanted to change from 45 to 60-day grace period?
I just threw it out as something we can consider. 45 is kind of tight,
Yeah,
doesn't maybe matter so much if we're gonna have all this other. My experience with the ones we reviewed were much longer.
mm-hmm.
Much.
Well, and that's, I guess, part of.
wasn't
part of-
47.
Yeah,
It wasn't.
well, so someone gets a new position and then a year later they send in a change. You've been doing this for a year, so if you knew you had to submit a change and you're doing it now, why didn't you do it then?
Yeah. Other thoughts on that?
I think if you're gonna have a change and you know you need to submit it, I think the 45 days is adequate time. I like the language change though, because it gives a little more flexibility and a little more direction. So not every single change has to be submitted, but anything substantial does.
Is there any pattern that you guys kind of have a sense of what the changes are that are getting missed? Because I could see a supervision shift that 45 days ideally would be best, but I could also see agencies struggling to get a new clinical person in to take over that spot within that 45 period based on, what we're seeing hiring wise as far as, agencies struggling with getting clinical staff. But
What it says, hours can be counted, so somebody's providing that if you're counting hours.
right.
Most of it, I would say, a good portion is changes in setting, either changing your position in the same agency, going from a private practice to an agency, or agency to private practice.
Then 45 days seems more than adequate for those kind of shifts to me.
One thing that's come up, someone mentioned to me, it's not on here, but related to this, is requiring a 2 years.
survey. Enter your PIN number to
You
join
can't
your
get your
conference.
clinical in less than 2 years.
Please hold while we place you into your conference.
It can be very frustrating for some people. Yeah, so one thing that just came up recently, someone mentioned to me, was the notion about the 2-year requirement, the minimum, meaning they're pretty much done with their hours. It's under the 2 years. I don't remember. It's probably been a year and a half or something, and they're done. Because this is what they do all day, every day. It's me with
Especially since we've lowered it from
Yeah,
3,000
that's a
to
good point.
3,000.
That's a really good point. So lowering the hours, probably, we have a duty to look at this, I think. Wow, that's a really, I didn't put those two things together.
Right, because somebody that has minimum billable hour standard of 25 hours a week, which is low. Is, I mean, they're banking 13, they're potentially banking 1,300 clinical hours a year. So to say, well, I know you're gonna be done, but in generally billable hour standards are higher than 25.
Yeah.
You know, if you got up to 30, you're $1,500 for 1,500 hours a year. You're done before that 2-year period would be up. And some people do more than that. They have a side job.
I imagine I know what the intent of this was.
Sure.
I want people rushing through in 9 months or something, but. Has anyone else brought this up?
I don't think so. No, the only thing similar to it is social work had previously had a limit that you had to complete it within 2 to 6 years.
Oh,
And the other professions don't have that upper cap limit. So that was recently a board recommendation to remove that for social work to match the other professions. But in terms of the 2-year requirement, I don't think I remember any discussion on it.
No,
You'd probably be worth it. I don't know who. Mental health centers would probably be a place that would have an opinion about that. You know, I know the folks that work for us that go and get their clinical license. They're not getting that kind of those numbers
right.
to get 3,000 hours in 2
Right.
years. It's taken three
Sure.
and a half years because it's a side job or it's just part of their position stuff or whatever it might be. So I'd have people think about it, right? Unless they're in the trenches doing.
New. So
Mhm.
this is something that
Yeah.
would probably kind of raise its head now. As people are like, I'm done way before that. Why can't I go ahead and apply?
Right.
I mean, it's affecting, I don't know. I think this is pretty important. But what do you guys think?
I always think it's a good thing to be more clear. And looking at this, I do think that we could change it somewhat to make it a little clearer. I know it's only a few folks, but I've had some of those same thoughts in those situations, Deb, and it would be nice to have something that would help us in that way.
What about in terms of lowering the 2-year requirement that people have to take basically the full 2 years to get their clinical hours? Now that they're lowered from 4,000 to 3,000.
I think with that lowering of the total requirement, reducing the amount, not prescribing 2 years might be. It would actually help probably quite a few, particularly those who are working CMHC full-time gigs where they're logging 35 plus hours of clinical contact a week. And then they have to just kind of wait. And if there's differences in reimbursement strategies, all that kind of stuff based on level of license. It could have, quite a bit of impact in multiple different ways to improve how it's working for them. So I could see that. But is there some sort of minimum we would want to do? I could imagine there might be a few out there that would, try to log their 3,000 hours in 12 months or 9 months or whatever. So
There would be.
yeah,
I think I can't see the board removing it. I was just gonna suggest if there's a time frame that we're comfortable with.
Well, if it's 4,000 hours, what it used to be over the span of 4-6 month period, then reducing that from 4,000 to 3,000, if you wanted to keep it proportional, would be about 1.5 years
Yeah.
instead of.
So I was thinking 1.5 years.
And that would make sure that it doesn't drop to too low of a level where you have someone working,
Right.
but it would stay proportionally to what had been before.
Yep. I like
forces
that.
forces them to stay within that kind of full-time job, not working 3 jobs to get it done faster kind of thing.
Right, exactly. What do you guys think? Are you comfortable with 18 months?
I think it makes sense.
Makes
I
sense.
got Christina's got her pondering look.
Yes, she
on.
does. That's what I was thinking.
No, I'm fine with, I think that sounds fine. I was just trying to think if there was something else, but no.
Awesome, thank you. I'm glad I remembered to bring that up.
Yeah.
Oh, I think the next one is yours, David.
Yeah, and I just wanted to make sure this was a kind of a placeholder here. So we talked a little bit about the new student addiction counselor license. So I don't really have anything really for the advisory committee to weigh in on this topic right now. It's just after July 1st, so that's when we would be able to start opening up the process for individuals to apply. So hopefully sometime in the very near future, we'll be sending out a message and posting it on the website that kind of adds more information on all the different items in the bill. But in terms of the forms and when they would be available, probably we're looking at people could start applying after July 1st. In terms of us issuing these, that's going to rely on the time frame with our licensing vendor too, from a technical perspective. But my hope is that sometime shortly after July 1st, we can start to answer questions and really look at this in a more concrete way.
Okay. Next item is discussion on reciprocity, years of practice or degree/education. So I think this came up briefly at the last meeting. I think maybe Leslie, you brought this up. That we get folks applying who didn't maybe go through the traditional, or their state doesn't require a bachelor's. So I guess you want to talk a little bit more about that?
So there have been, from other states, they have requirements of, sometimes their training is not through a college or university. It's specified for
Oh, yeah,
this
like a
credential.
certification?
Yeah,
Okay,
and so they don't have,
like problem gambling.
yeah. So they don't have the normal, degree or coursework. Even if they have a degree, they don't have the specified coursework because they can't count those trainings. Some of the credentials only require high school diploma. Some don't require anything. So it really varies for your profession. The different requirements for the different states, and the bachelor's degree is sometimes an issue.
So what we're pondering is whether we would like to change. Is this a reg change? Statute change that allows people coming from other states that we would consider years of experience in lieu of a bachelor's degree.
How is that experience documented though? Like, how would we know that
We
they
have-
have all these years of
Yeah, we have
experience?
Now that
Now we have 4 years, it's changed to 1. Well, it's actually, the new law doesn't require any practice. It only requires that you be licensed for a year. after July
So we're not,
1st.
but we were doing. that.
Yes, we were doing 4 years of
And
practice.
so how did we,
We have an attestation from the employer or from the person themselves if they are in a private practice. So
it's
we
pretty,
trust that you're being honest.
but we would require anything we wanted. We
Right.
could require
Uh-huh.
that someone that you know, the agency or someone you worked for to fill
Mhm.
something out.
Right.
Do we have any sense of how often this happens?
No, because people don't apply if they don't have the degree.
I will say, I think this issue in some way might be responded to, so if we weren't comfortable changing that. I know the people who wanted the student temporary license had people like this in mind. Maybe they worked in another state, maybe they have full of experience, but they've
Mhm.
only got some college hours,
Right.
kind of thing. But I think in my mind, we would want to know that if we're gonna say, if we're comfortable with experience and live with bachelor's degree, that we're talking about somebody who's had this practice. They've been an addiction counselor in another state and recognized as doing that work by that state. Do we let them come over with no additional education?
And they would be coming to do the counselor in training to see if,
No, what's on the table is, do we allow them? I think that could always be an option, right? If I don't have any idea how this would look, but you could always send them down that track to get additional something or other. But in general, what I'm saying is no. They have 10 years experience doing addiction counseling. They have some sort of credential from Missouri.
Mhm.
And they want to come over here and do it. And 10 years was our minimum. Do we just let them come over and become an LIC? Would make them take a test. I don't know how many, did they do tests over there in Missouri? Does anybody know?
I believe they do for the CADC level and the advanced counselor. The folks that are at their first level, which is MADAC 1 and MADAC 2, there is no testing associated with that, and Missouri can hold the second level indefinitely. They are not a ladder that continues onward. I would say that probably if we're going to move this direction, using the ICRC's credentials, which a lot of states do, it would have to be that, what do they call it? The alcohol drug counselor, whatever version the state has of the ADC, the full level certified counselor, not the ones in training, not that lower level, if we're going to head that direction. But then that kind of begs the question of, well, if we're requiring those in Kansas to meet that higher bar, and then bringing these other folks in from elsewhere, why? And I'm sure this was discussion that happened, moons ago when you guys talked about the licensing change to require the bachelor's.
You pretty much hit the nail on the head. The LIC was a non-starter with the rest of the board at that time if we did not require a bachelor's degree.
I would say at least I don't know, 5 years with that credential, the full credential being awarded or something. I think it needs to be a little bit more time frame to get to, make sure there are folks that have been doing it and they just haven't jumped into, I'm only familiar with Missouri's with lots of familiarities. So I know there's lots of variations on the states on how they credential these folks at this level. So.
And the ADC, do you know, Mike, is the ADC exam equivalent to the NCAC 2? That's what we use.
Mhm.
I am not 100% sure based on just the way they level things with the ICRC stuff. I would say it's probably closer to the 1 over the 2.
Okay.
Um,
We allow the ADC, so that's why I was asking.
I would have to go a little bit, I haven't looked at that exam a whole lot just because that's not the direction most of the students here are headed for their.
Right.
And I let those that are doing it Missouri or Texas or wherever do their thing and they talk to the regulatory board there and I try to stay out of that because I don't want to advise them on stuff that's outside my scope, but
I guess one thing that comes to my mind, I mean, workforce always, that's an issue, right? We want to try and increase workforce, and getting back to Jason's point about public safety. I'm wondering, oh, Lisa just left. I was wondering if maybe even the ATTC or somebody had, I guess my concern is that we've kind of increased the level again of competency, or said you have to be this competent to provide these really crucial services to people in need. Then we don't know what other states require. Like if that's open to any state, it's not just Missouri. I don't know what's happening in New Hampshire, or, what are the requirements in other states? Is there a uniform kind of level of competence that is required? And if it's not, I mean, somebody could be practicing for 5 years. It doesn't necessarily mean that they've met any like that they've had training, or, they have experience. But I could have experience in doing something in a way that's not as helpful or even harmful. It doesn't mean that I'm, practicing in a way that we've said this is the competence in our state to be able to provide to our citizens. So I don't know. I don't know if there's a way to, like you were saying, if there's a way to ensure that, whether it's a test or some sort of references or, something that's in addition to make sure that folks are, providing to this, a population that's very much in need, and a lot of times is marginalized and at risk. And so we want to make sure people are where they need to be, I guess.
That's kind of what I was thinking too. I wouldn't want to say no, absolutely not. But at the same time, as a licensed addictions counselor, I'm like, dang, I had to work hard to get my, license and make sure that I meet all of these boxes and make sure that I'm doing good client care. And how do we know that, yes, they've met their competency and done all of the things that I know that I've had to do? But I wouldn't want to just absolutely not, they can't be licensed. I don't know. That's a tough one.
I haven't looked at too many states, Christina, but I have had the opportunity to look at probably 3 or 4 in the last couple of years because students inquire. And there is very little uniformity across states. There are states that have licensure and credentialing both. And usually the license requires additional formal educational process versus the certification, which is the training process. Our neighboring states are primarily the ADC level ideas. And not all of them have those lower level trainee type of credentials like Missouri do. A lot of them have a temporary one and they have to get to the CADC level, what used to be CADC here, and what Missouri sees as that. So there's just all kinds of variation, and some are, week-long trainings, and it's all over the chart. But I have had people who've inquired and, they got 20 years and they ran agencies and all that kind of stuff, and they can't work here because they don't hold a bachelor's degree. And that to me doesn't make a lot of sense. There should be a pathway for folks that have, some way to document or confirm that they have the competencies, or at least attempt to. And maybe it is the test, having them pass the NCA. I'll get it wrong, too, and move from there. I don't know.
Yeah, I mean, I think there needs to be something. We were just having this, I was in Iowa last week and we were talking about, like, with peer support, they're facing some of the same things, is that some states are requiring, like, again, there's this competence and there's this training, and then other states are saying, well, you've got a year, and let's, being in a recovery process and have that lived experience. And so then that, and that there is a difference in, different levels of ability. So I don't know. Lisa's returned. I don't know if we could pick on Lisa and ask, do you know of any listing of, like, states, what their requirements are, or would the ATTC have access to any of that? Like, what are the requirements for different states to be licensed, credentialed, to provide service?
I can certainly look into it. I mean, none are coming to my mind at this
Okay.
very moment, but yeah, I can check into that. See if there's a matrix maybe that somebody did.
Yeah, that's what I'm thinking. Maybe somewhere somebody has thought this same exact thing, maybe.
Yeah,
That would be helpful, maybe to get an idea of that.
okay. I can research that next week.
Thank you.
I'm gonna have to get on the road, folks, because I've got a 3-hour drive, so I'm gonna sign off here in a couple minutes.
Thanks for logging on.
Thanks.
All right, good discussion. You guys can think about it. I'm certainly in favor of a test anytime you're going to waive education requirements. So,
So would it be 4 years of experience plus passing the exam?
yes, plus references. Testing to your practice.
I'd never make it.
Which test? Which one? The same one that they would take to,
It could be either test, really. We don't prescribe which test it is.
We use NCAC too.
Yeah, but it wouldn't have to be. Maybe it's an ICRC.
Oh, we allow, yeah, ICRC, yeah, exams as well, but like the NCAC one is an associate level, I think, or not.
So we would accept the
degree.
ICRP, right?
Well,
We do now, so
Yeah.
yeah.
it sounds like this is a really good discussion. We are getting close to time, so maybe this is a good conversation to continue at the next meeting and.
Yeah, definitely. Okay, so David put continuing education regs and documentation of continuing ed in your packet. And I have just a couple of quick things.
And for reference, this is 102-7-9 for continuing education. And then the documentation of continuing education is KAR 102-7-10.
I found this review enlightening for me.
That's kind of ominous.
Yeah, that's a bad thing to say, isn't it? All right, I'm just continuing ed. Do I need to watch my time then?
I think we were at the time we would normally end, but we can go over. So
Okay,
yeah, as long as we
Alright.
still have.
it's good to go over about 10 minutes.
Sure.
So on continuing ed, so it'd be, what is that? D4. If a post-test is provided, an activity consisting of completing a computerized interactive learning module, viewing a telecast or videotape, listening to an audio tape or reading, the maximum number of allowable continuing education hours shall be 30. The post-test is not provided, an activity consisting of completing a computerized interactive learning module, viewing a telecast, blah, blah, blah. The maximum number of allowable continuing education hours shall be 5. Okay, I will attest that I had not really paid a lot of attention to this piece in this world of internet trainings. Whether I had a post-test or didn't have a post-test. So it feels like this is something we should look at if we still want to limit the hours and say you can't have all 30 if there's no, I don't know. Some have post-tests, some don't. I've never worried about it when I'm looking to count my hours, so there you go, full disclosure. So that's one thing. Number 6. Go ahead. Yes,
Just
I'm
real
gonna-
quick, does that, and that differentiates between live, like Zoom versus asynchronous training? Is there a differentiating there?
No.
Now, these are old.
Okay.
Oh.
So, and we've actually, Dave and I had discussed this because psychology says an APA approved training.
Oh,
And so now for APA approved trainings, they take their trainings and they offer them as webinars. So it's not really live, but it's not really
yep,
just reading a book.
right,
It's very different.
yes.
So, yes, this is a good.
Well, I guess my 2 cents on the whole thing is that 4 and 5 are too prescriptive. We need to be sure that, again, our regs are indicative of real life, what's actually happening out there. there's lots of other ways that we allow some extreme flexibility, honestly, on some of these. So I don't know why we're being super prescriptive on this, except for we have a bias against this kind of training and these kinds of experiences and this kind of reality in general when these were written, which we clearly moved away from.
And for reference, these were last updated back in 2012.
Yeah. I personally, I think
Right after they were
doing a
promulgated.
training, a computerized interactive training is different than reading a book.
Yeah.
I think reading a book should be limited to 5.
Yeah. Yeah, no, I agree. Yeah.
Well, yeah, and I think even like with what you're describing, like a webinar where it's taped, there's still, I mean, is there a way that they can ensure that, and I mean, we get back to even if you're in person, how do you ensure the person's actually listening and participating? They can sit there and be doing whatever. And so, you know, having some accountability there for the hours versus just kind of, oh, I read this book and it took me 10 hours to do it. Versus a webinar, which is an hour or 2 hours, and there's probably a CEU that's associated with it that goes in there. But I would agree. I don't know. We have like 4 minutes left of the 10. I mean, I think, yes, this needs to be looked at. Is that something we can do to maybe put on the agenda first and foremost, maybe
This
at our
is
next
really just
meeting?
to familiarize you guys with it,
Yeah.
not to have a deep dive.
Okay.
Probably won't be at the next meeting, so I'm getting all my 2 cents in right now. That's what you're doing.
I would
Um,
agree, Deb. I think this needs to be looked at for sure.
The self-directed learning project, I don't know how often that comes up. I'm not a big fan of it personally. I-
I'm not either, because it doesn't come up very often and there's nothing.
There's no other, see, this is my
There's nothing
point.
to
We're
go by.
super prescriptive
Right.
about a post-test. But we're gonna let you do a self-directed with no other instructions. I don't even know how I feel about doing supervision, but you all, as something part of CEUs, whatever, you guys can haggle that out. I didn't know if I was ever short hours, my participation in professional organization, oh my gosh.
I know.
But it doesn't really say how to document that or how to prove it. So that's another thing, if we're gonna continue to allow it. Personally, I'm okay with taking it out.
So
Well, I think we could
Add a little bit.
review. This isn't a copy of other disciplines,
Well,
continuing education, is it?
and there is
No,
that,
this is just yours.
just yours, yeah.
Yeah, I would take something out if it's allowed somewhere else.
Yeah, there is a
Right.
companion regulation too that has to do with documentation.
That's true, which is where I'll go looking at.
102-7-10.
Yeah,
so.
yeah. I've got a copy.
Yeah, I think this is something for further discussion, I think.
Oh, you're right, it does say that.
Item
Yeah,
J.
because where I got caught up and all my highlights was a copy should not be accepted. Which I think needs to be stricken,
Yeah, I agree.
because I promise you, I would have been in big trouble in an audit.
Well, and I mean, we tell people they can email things now,
Yeah,
so,
that's my point.
yeah,
I don't even get hardly anything that isn't copied, right? Even when I attend in person, usually the person, whatever name is
right.
over and over again. Okay, good. So you guys can pick that up next time. All right, so David and I were looking at the calendar. In the event that my replacement is not picked, then I wanted to be available to meet. And so that date in August is a date I'm available, even though it's not our normal,
What's the date?
the
August
25th.
25th.
At 10 a.m. So are people available for that date and time?
Let me check.
Could
That
be
was
a good-
August 25th. Is that what you said? August 25th? Yes. Okay.
Well, we'll see if the new person can meet at that date and time, but I'm sure David will be communicating with all of you. It's been my complete honor to chair this advisory committee for many years and to work with all of you. And I will miss you all very much. Hope to see you around.
Well, and on behalf of the agency, thank you, Deb, for serving as a board member and also chair of the advisory committee. And it will be very different. We will definitely miss you.
My person of knowledge.
You know how to reach me.
But thank you, sincerely.
Thank you. Yeah, thanks to the staff. Big help with this whole process. Can't do it without them. Anything else? Motion to adjourn?
So moved.
Thank you. Second,
I'll second.
all in favor, say aye.
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 Have a fantastic rest of your weekend.
Thank you.
Thank you, everyone.
Deb, I feel like we should have had a cake or something. Like cupcakes, something. If this is your last meeting.
Thank you.
Thanks.
Bye-bye.
Bye.